Good morning. As already introduced, I'm Mercy Ponda Malidungu, and my presentation this morning is on the role of a prosecutor in the appeal process. So, the appeal process is an important process in the justice system in that it allows for the review of a decision of a lower court. This is aimed at ensuring that the higher court is given an opportunity to review the decision of the lower courts so as to correct errors and ensure that justice prevails. Therefore, the appeal process provides recourse for persons who are not satisfied with decisions of lower courts. My presentation this morning is focused on criminal appeals. So, as prosecutors, we need to know and understand our role in the appeal process. It is important that we know the provisions of the law relating to appeals and documents to file at any particular stage of the appeal process. We also need to skillfully draft required documents and present our arguments clearly and persuasively. Even as we handle our appeals, we should be mindful that we serve justice, and justice should be served not just for the convicts, but also for the victims of crime. We need to consider the interests of victims of crime and the community at large. So, as prosecutors, we should not just wait for convicts to appeal and attend to such appeals. We are required to be alert and initiate appeals on behalf of the people in cases where we are not satisfied with a decision of the court. Even in a session where you have secured convictions but one acquittal, if there is need for you to appeal in that one acquittal, it is important that you appeal and not be comfortable with the main convictions that you have secured. So in the Zambian jurisdiction, we have the Courts of Appeal, the High Court, and the Supreme Court as courts with appellant jurisdiction. So the acts governing these courts also provide for appeal processes in the respective courts. Therefore, in order to effectively and efficiently discharge our role in the appeal process, we need to be conversant with the provisions of the law governing appeal processes and procedures. Having said that, I'll now look at the appeal process in the courts I have referred to. So, appeals to the High Court. That is the provision of the law on appeals to the High Court. That is section 321 of the CPC. So, a person convicted by the subordinate court may appeal to the High Court against his conviction on any ground of appeal which involves a question of law alone, or a question of facts alone, or a question of mixed law and fact. A person may also appeal against the sentence passed on his conviction unless that sentence is one fixed by law. I'll give an example of the charge of defilement, where the mandatory minimum sentence is 15 years. So where the court has meted out a sentence of 15 years, an appeal against that particular sentence cannot succeed because this is a sentence which is fixed by law. The Director of Public Prosecution can also appeal. We are allowed to appeal. But what we have to bear in mind as the state, that we can only appeal on a point of law. I'll speak to this later in my presentation. So time within which to appeal. So appealing against the decision of the subordinate court to the High Court, the appeal has to be filed within 14 days of the date of the decision. What has been happening in practice is that courts, subordinate courts, usually read out untyped judgments. So by the time the judgment is typed, we would have run out of those 14 days. So how can we go around this? So where we have heard the judgment, even as the court is reading the judgment in court, and we feel that this judgment should be appealed against, it is okay for us to stay within the 14 days to lodge an appeal by filing a generic ground of appeal. We also indicate another ground of appeal stating that other ground will follow upon perusal of the judgment. In that way, we'll be able to stay within time. I know the 14 days is not sufficient, and we usually appeal out of time, and that is allowed. The section further indicates that no appeal shall be heard unless entered in the case of an appeal against sentence within 14 days of the date of the sentence. So even as the state, where we are not satisfied with a sentence that has been imposed by the court, we can appeal against that sentence. The law goes further to indicate that in a case of an appeal against conviction, within 14 days of the date of sentence imposed in respect of such conviction. So a careful reading of this provision reveals that one cannot appeal against their conviction before sentence is pronounced. That appeal will not be entertained. So the 14 days in this regard will start running after the court has pronounced its sentence on that particular conviction. I know we've had instances where some appellants do appeal against conviction even before the sentence is pronounced. But we should be mindful of this provision, that that is not in order. Appealing out of time. As I mentioned earlier, even when we run out of time, we can appeal out of time. So where the period within which to appeal has expired, an appellant may nevertheless make an application in a prescribed form. So there's a prescribed form in which to appeal out of time. And the form of application has to be attached to the notice of appeal when the notice is filed. I'll also speak more on this later. So required documents to file and where to file them. So in this regard, it's a notice of appeal in the form prescribed, and this is Form 33. When out of time, an application for leave to appeal out of time is also in the prescribed form and filed together with the notice of appeal. And these documents are supposed to be filed in the subordinate court. I go to appeals to the Court of Appeal. So those are the provisions of the law governing appeals in the Court of Appeals, sections 14 to 21 of the Court of Appeal Act. and Order 9 of the Court of Appeal rules. So in the Court of Appeal, we have first and second appeals. So a first appeal is an appeal against the decision of the High Court in its original jurisdiction, while a second appeal is an appeal against the decision of the High Court in its appellant jurisdiction. So the law governing appeals in the Court of Appeal also talks about the DPP appealing only on a point of law. We cannot appeal on a point of fact or mixed law and fact. We can only appeal on a point of law as the state. So even as we draft our grounds of appeal, we should bear in mind, we cannot say the court erred in law and fact. No, it's only the court erred in law, because we are only allowed to appeal on a point of law. Time within which to appeal. So when appealing against the decision of the High Court to the Court of Appeal, we have 30 days within which to lodge our appeal. The court may extend the time for giving notice of intention to appeal out of time. So even when we've run out of time, and this rarely happens when we are appealing to the High Court, because I think the 30 days is sufficient for us to lodge our appeal. So we rarely appeal out of time when appealing to the Court of Appeal. But nonetheless, there's provision where we've run out of time, where we can apply for an extension for us to appeal of time. So required documents to file. So we have the notice of intention to appeal, that is in Form 8. We also have grounds of appeal, which should be set out as prescribed in Form 10. And in an application for extension of time, a notice of application for extension of time as set out in Form 22. So these documents are to be filed in the Court of Appeal. I go to appeals to the Supreme Court. So essentially, Section 13 of the Court of Appeal has provided for appeals to the Supreme Court. So an appeal against the judgment of the Court of Appeal shall lie to the Supreme Court. But here, what we have to have in mind is that we cannot appeal to the Supreme Court directly. So when we intend to appeal, we first have to seek leave from the Court of Appeal. Only when the Court of Appeal has granted leave for us to appeal to the Supreme Court, that is when we can appeal to the Supreme Court. The section also sets out grounds upon which leave can be granted, and these include instances where the appeal raises a point of law of public importance. A case in mind on this point is the case of a child in Petauke who brutally murdered a lady. So in that particular case, the child could not be given a custodial sentence as per the provisions of Section 79 of the Children's Code Act. In that regard, the child was put on probation. And as we were not satisfied with that particular sentence, also bearing in mind that there's that provision in the Children's Code Act, we still went ahead and appealed. We appealed to the Court of Appeal. The Court of Appeal dismissed our appeal. It indicated that its hands were tied because of the provisions of Section 79 of the Children's Code Act. So our appeal was dismissed. We were not satisfied, and we didn't end there. We went to the Court of Appeal and sought leave to appeal to the Supreme Court. As you may be aware, the Court of Appeal rarely grants leave to appeal to the Supreme Court. But in this particular case, the court granted us leave to appeal to the Supreme Court. And we have since filed our notice of intention to appeal in the Supreme Court, and we are waiting for the apex court to list the matter and pronounce itself on this important point of law regarding sentencing of children. So in that case, the Court of Appeal ruled that the court's sentencing options under the Children's Code Act is a point of law of public importance. So our view on this case was that even as we are protecting the rights of children, we should also protect the community in which they live. Time within which to appeal. So an application to the Court of Appeal for leave to appeal to the Supreme Court has to be made within 14 days of judgment. So within 14 days of judgment, we have to lodge our application for leave to appeal to the Supreme Court. And when leave has been granted, then a notice of intention to appeal has to be filed in the Supreme Court. Those are the provisions of the law and the procedures that are supposed to be followed, even as we appeal to these courts I have talked about. Documents to file and where to file them. A notice of motion with an affidavit exhibiting relevant documents is filed when seeking leave to appeal to the Supreme Court. So this is filed in the Court of Appeal. And a notice of intention to appeal with grounds of appeal is filed in the Supreme Court after leave has been so granted by the Court of Appeal. I go to the last part of my presentation, and I included this part in my presentation because of the interactions and concerns that have been raised by some of our prosecutors, even as they handle appeal cases. So one of them is the one to do with instances where an appellant has not appeared to prosecute his appeal. So in that regard, the court may determine the appeal summarily. So where an appellant has not appeared for any reason, the court is not supposed to dismiss that appeal for want of prosecution. The court can determine the appeal summarily based on the grounds of appeal that were filed with the notice of appeal. So we should know this provision of the law, and we should not be quick to request the court to dismiss the appeal when an appellant has not appeared, because the law sets out the procedure that the court has to follow, and this is to determine the appeal summarily. Rule 12 of the Court of Appeal rules also has a similar provision where the appellant has not appeared to prosecute the appeal. The Director of Public Prosecutions can only appeal on a point of law. So this requirement has to be observed as we draft our grounds of appeal, as I mentioned earlier. And this should not pose any challenges in appealing. What is important is how we draft the grounds of appeal, as I mentioned earlier. The case of DPP versus Ingandu is very instructive on this point. And a careful reading of that particular case shows that a finding of fact which is not supported by evidence is a point of law on which the DPP can appeal. So having this in mind, we should not be having challenges, even with the rather restriction we have of only appealing on a point of law. So what is important is how we craft our grounds of appeal. As I mentioned earlier, whenever we are appealing as the state, we should only appeal on a point of law. We cannot say the court erred in law and fact. Ours is to say the court erred in law only. Appealing against the decision of the subordinate court out of time. So when appealing against the decision of the subordinate court to the High Court out of time, a notice of appeal has to be filed together with the application to appeal out of time. So the application to appeal out of time is made by completing a form that is attached to the notice of appeal. So the notice of appeal has a form behind it where we have to set out our reasons as to why we are appealing out of time. So this form is attached to the notice of appeal, and when filing our appeal out of time, this is the form we should fill in and set out the reasons as to why we are appealing out of time. And the documents have to be filed in the subordinate court. Also note that when we are appealing out of time and the documents have been submitted to the subordinate court or filed in the subordinate court, they are transmitted to the High Court, and it is the High Court that makes the decision as to whether to allow us to appeal out of time or not. So this determination by the High Court has to be made summarily. That is without the presence of either party to the case. So there's a provision on that form where the judge has to indicate his decision and also append their signature. So this is done summarily, such that when the matter is cause-listed for appeal, the matter is cause-listed for hearing of that particular appeal and not for hearing as to why we have appealed out of time. We've had instances in the recent past where the courts, when the matter is cause-listed for appeal, the courts are asking us to file summons with accompanying affidavits, setting out reasons as to why we are appealing out of time. According to this provision of the law, this is not in order. So this determination by the High Court has to be made summarily. And when the matter is cause-listed, it is for the hearing of the appeal and not our application to appeal out of time. Revisionary powers of the High Court. This is also another aspect in the appeal process, which has attracted a lot of questions. We've received a lot of questions on this point as a department. So the High Court has power to call for the record of any criminal proceedings before the subordinate court and examine it. The High Court may also call for the record, or the record may come to its knowledge in any other way. So in practice, the question has been whether the High Court can review a case that is before it for sentencing. We have had different arguments on this point, even from the court. So when a matter is before the High Court for sentencing, the court is deemed to be the convicting court. So the High Court is deemed to be an extension of the trial court that convicted the person. Because of this provision, some schools of thought argue that in that regard, then the High Court should just pass sentence and not proceed to review the matter because it is deemed as an extension of the trial court that convicted the person. The other school of thought on this point argue that when the matter is before the High Court for sentencing, then it has come to the court in that other way, which is provided for by the CPC. And if it has come to the court in that other way, then the court should have power to review the case where it has observed errors. So people argue on this point that there's no way the High Court can observe errors and still proceed to pass sentence regardless of the errors that have been observed. So these are the two schools of thought that we have on this particular issue. And I know we have been faced with this issue and the courts have been dealing with the matter differently. So the cases in point on this one, and these are Supreme Court cases, which also seem to be differing in the position. So these are the cases of Bright Kawame. In the case of Bright Kawame, the court held that, in our view, it was not for the High Court, constituted as a sentencing court, to embark on anything resembling a review of the trial court's judgment. Yet again, in the case of Nathan, the Supreme Court held that the party cannot invite the court to review the matter when the matter is before the High Court for sentencing. I know the Chief State Advocate will have more to say on this one. In conclusion, ladies and gentlemen, as prosecutors, we play a vital role in the appeal process. It is our duty to ensure that justice is served, not just for the convicts, but also for the victims of crime and the community at large. So let us continue to be alert and ensure that we appeal cases that need appealing. It is our duty to promote justice and bolster public confidence in the criminal justice system. I thank you.
Thank you, Mrs. Lungu, for that wonderful presentation and done within time. I will invite two questions before I do. We have heard in summary when the DPP can appeal and the time frames within which we can appeal from the subordinate court to the High Court, from the High Court to the Court of Appeal, and then Court of Appeal to the Supreme Court, and also what the first appeal is, and also what a second appeal is. Again, also we've been told what to do when an appellant hasn't appeared before court. I will take two questions. Okay, I think we can have more questions, but before you proceed, I would like the Chief State Advocate to comment on what was highlighted by Mrs. Lungu. Chief State Advocate. Could we have the mic here, please?
Oh, thank you for the opportunity. As highlighted by Mrs. Lungu, the issue of revision on sentencing has become a topical issue with varying judgments, as has been highlighted. Uh, and Mrs. Lungu mentioned that there are two schools of thought on the issue. And I must admit that for the school of thought that argues that the court can still look at the propriety of the judgment at the time of sentencing. My argument is based on Section 338, which seems to suggest that other than the court reviewing a case when it calls for it, the court can also look at the case for which comes to it otherwise. So by otherwise, I can confidently argue that it can also mean when it comes for sentencing. If when you go further, the provisos under Section 338, they provide for what the court can do, the sanctions that the court can come up with. One of them is I'm trying to open the Criminal Procedure Code. Yes, so one of them is it can quash the conviction, it can uphold the conviction. So that is the court exercising its revisionary power. So by that, I believe that it can relook at the propriety of the conviction that the trial court imposes. Further, and just looking at it from like the right angle, the rights of accused persons, even for us as prosecutors, would we be comfortable proceeding for sentencing where we notice from the record that the conviction, even from our perspective, was not proper? For example, I was looking at a case yesterday that came from Eastern Province, where they are proposing that we should appeal. My view is that possibly we may not appeal because one of the major components that the court did not that looked at in acquitting the accused was that we didn't prove the issue of the age of the victim. We didn't strictly prove it as required by law. The case happened before the Children's Code Act came into place, where we needed to prove age strictly by calling either the parent or bring documentary evidence that will show the age or medical evidence. So now, if we see that on the record, it's manifestly clear that the trial was not properly conducted, the rules were not followed, the procedures were not followed. Could we proceed to urge the courts to sentence? So I believe the best way would, at that stage, where it's manifestly clear that the procedures were not followed, the court has a right to relook at the propriety of the conviction and uh, reverse it or send back the case for retrial or acquit. On acquittal, I'm not sure if that should be proper, but I would argue that it should be sent back for retrial so that all the legal provisions are taken care of. That is my submission.
Thank you, CSA. Thank you very much for that. Yes, we can have the first question. Before you ask your question, kindly just state your names. State your names, the institution where you're coming from, and please keep your question brief. Don't give us a thesis.
It's not.
Maybe you could walk to the front and just use that mic.
Good morning. I'm Georgina Daka from Lusaka Province, a senior public prosecutor. I'm grateful for the presentation that has been made by Mrs. Lungu. However, I do note that one thing was not really picked out. To be specific, what I noticed is whenever the state secures a conviction, you'll find that the accused person, through their lawyers, will appeal. They'll apply for bail pending appeal. Once that is done, from my number of years of practice, I do notice that cases actually die, for lack of a better term, they just die a natural death because I've never seen the state push for that to say what will happen next. And when you look at the CPC, there's no provision which actually specifies what happens thereafter because I know of a good number of cases where the one was convicted and a conviction, of course, was secured. But after they have applied for bail pending appeal, the case just died. So what is it that we are doing as a unit from NPA to keep such cases? Thank you.
Thank you so much for that question. In my presentation, I talked about what should happen in an event that an appellant has not appeared to prosecute their appeal. Most of the times, we are quick to request the court to dismiss the appeal. So, like I mentioned earlier, that should not be the case. We should call upon the court to look at the matter and determine it summarily by looking at the grounds of appeal that were filed. So, in an event that the court upholds the conviction, then it is upon us to ensure that the appellant is traced and put in custody. So it is our duty, all of us, as state advocates and prosecutors, even as we are faced with these cases, to take it upon ourselves and ensure that due process is carried out. So where you are faced with such a case, as a prosecutor or advocate, take it upon yourself and ensure that this person is brought to book. The court has to decide the appeal summarily, even if the appellant has not appeared. Thank you.
Thank you, Mrs. Lungu. Mr. Munkombwe, I think that will be the last question. Yes, you come in front. Looks like the mics are not working.
Okay, I think maybe mine is just a follow-up. My name is Chimunya Munkombwe. I'm from NPA. I'm senior state advocate from Eastern Province. My question is just a follow-up on section 325. This section talks about the appellant being absent. Now, we have a number of cases where it is the way the appellant has been, the accused is acquitted. Then as the state, we appeal. And when we appeal, the matter is cause listed for hearing, the respondent is absent. I think I've had a number of such cases. And then judges usually fail to proceed. How would we proceed in that manner? Thank you.
Thank you so much for the question. So, when an accused person has been acquitted, they are at liberty. I know I've received questions from advocates and prosecutors asking how they should go about it. I'm also informed that in certain instances, the court will ask the state to apply for a bench warrant, but that is not in order because this person was acquitted, so they are at liberty. On what basis are we applying for a bench warrant? That should not happen. So it is just for us to put in administrative measures on how we can secure the attendance of the respondent. Let us just be vigilant, involve the police, and trace addresses from the docket. We just have to do what we can to ensure that the attendance of the respondent is secured. Applying for a bench warrant is not acceptable because remember, this person was acquitted, therefore they are at liberty to be wherever they want to be. Thank you.
See,
Good morning, everyone. So, there's a team that currently is working on the review of the Penal Code and the CPC. And of course, it has come to our attention that the issue of the role of a sentencing court is an issue that has been discussed by the team, and the team is split, just like the court. And this being an interaction that is meant to elicit responses, even if they're different, I would be very interested to hear someone in the team, in the auditorium, who believes that the court is restricted by the provision on sentencing in the CPC, and the otherwise in the review provision really is there to just accommodate issues of maybe a complaint being made to the judge in charge over a particular case. The CSA and I would like to hear any other opposing view, if there is any.
specifically
brave.
from the people in the team?
Yes,
Yes.
from the
Okay.
team
Anyone?
here.
Ms. Ndugwe, are you on the opposing side of that position? Or Mr. Waluzimba? We can hear from.
Or he's on the other side.
No, I'm just making a wild guess. Are we going to have someone to volunteer? Mr. Bako? See,
Mrs. Lungu, tell us your perception, the provision. I hear you're on the other side.
Thank you, Ms. Soko. So, like you rightly indicated, even as the committee reviewing the Penal Code and the CPC are split on this issue. I am of the view that the court, being deemed as a convicting court, should proceed past sentence. What has been happening in practice is that the court would even call for submissions from parties, and the sentencing session is turned into more like an appeal session. So, because of that, my view is that the court should pass sentence. And when a party is not satisfied, then they appeal, as opposed to treating the sentencing session as an appeal session. That is my view on this point.
thank you. I think I'm of the similar view. So the convicting court should adopt the errors of the trial court because it's also a trial court in essence. Okay, we have several questions on this time, but this being the last day, we want to finish early. And also, we've got a lot of sessions and we want to do justice to the other topics. I would encourage you to engage. We've got the NPA forum. We could discuss that on that forum so that, yes, we interact. I will close the session and I'll invite you to clap for our presenter for the wonderful presentation. Our next topic will be to look at the role of DNA evidence in criminal investigations and prosecutions. And to help us discuss that topic, we have Mr. Innocent Makasa, the State Forensic Analyst. I'm trying to see, I didn't meet him. IT, could you help us with his bio? Should it just be screened so that we look at his bio? IT? Okay, the bio may follow when we are asking questions. So let's dive right into the presentation. Mr. Makasa, you're welcome.
Thank you very much and good morning. I want to start by stating a fact that relates to DNA